Ladies and gentlemen, thank you for standing by. Welcome to today's conference call titled Key Regulatory Concerns: A Governance Perspective. This time, all participants are in a listen-only mode. Later, I'll be opening for your questions. Instructions will be given at that time. If you require assistance during the call, please press star and then 0. As a reminder, today's conference is being recorded. Now, I'd like to turn it over to Ms. Michelle Cooper, Senior Vice President and Corporate Responsibility Officer for CHI. Please go ahead.
Thank you, Paul. Welcome, everybody, and we're pleased to offer another quarterly webcast education for Board and Audit and Compliance Committee members called Key Regulatory Concerns: A Governance Perspective. This is actually the second time that we've done this webcast. We did it originally in 2013, and we decided this year would be a good year to update this education since it's so important for Board and Audit and Compliance Committee members to understand the key regulatory concerns as they act in a fiduciary role with CHI and our entities. This will be our required Board and Audit and Compliance Committee education for fiscal year 2018. So those of you that are listening today will have already met your requirements for fiscal year 2018. Before we get started, I would like to offer the following opening prayer. And it's called God is Seeking Me. Loving God, what is it that you would have me do? It is not what I want you to do. It is what I want you to be. Be a child of God. Be my light in the world. Be my presence among my people. Be kind and just. Be loving and generous. Be joy-filled. Be courageous and visionary. Seeing things as they could be rather than the way they are. Be fearless and trusting. Be a witness. Be present. Amen. And with that, I would just mention that we're going to offer questions and answers at the end of this session. I also just wanted to remind everybody that we are recording this webcast. So if you have specific questions around a particular investigation or regulatory concern in your market, we ask that you not ask those specific questions on this call, but keep the questions more generic in nature. And with that, I'd like to introduce first Susan Shipwood. Susan is Assistant VP for Corporate Responsibility at the national level. Susan has been with CHI for 26 years. Before joining the CHI National Office 14 years ago, she worked with Penrose in Colorado Springs. And Susan has a health information management background, but has been in compliance for over 17 years. So we're excited to have Susan speak. Secondly, we have Kyle Robinson, who is an attorney with CHI's Legal Services. He's now in his 4th year with CHI, and he primarily supports CHI Health at Home system. But in addition to this work involving home care, hospice, DME, and patient infusion, Kyle specializes in issues involving compliance, informed consent, and virtual health. I'd also like to introduce Benjamin Rowe. Ben is the newest member that helps support the compliance team. He's also an attorney with the CHI Legal Services Group. He's been with CHI since 2013 and supports CHI Clinical Research, which is the Catholic Health Institute for Research and Innovation. He also assists with compliance and information technology issues. So with that, I'll turn it over to Susan Shipwood.
Thank you, Michelle, and good morning, everybody. So on slide 2, these are the objectives for today's webinar. We want to provide you with an overview of 4 key regulations that govern what we do in healthcare. This will be a basic understanding of the regulations for antitrust, the anti-kickback statute, physician self-referral or the Stark Law, and False Claims Act. And so just a basic understanding to help you understand, the healthcare complexity, I guess, but it will help you to perform your fiduciary role from a compliance oversight perspective. And then we'll talk about some key takeaways to help you in your fiduciary role. So these are some of the areas of government concern and some focused areas. I'm on slide 3. Obviously, the government is concerned about the quality and the overall cost of health care. And accurate claims submission is definitely a focus. We need to make sure that claims are appropriate. The government's interested. They want to know that the claims that we submit for services were actually provided. They want to make sure that the claims that are submitted are for services that are medically necessary. They also want to make sure that, even if the services are necessary, were they provided in the right care setting? So, for instance, was it provided in an inpatient setting, and it should have been provided in an outpatient setting? Also, there might be services that were medically necessary, but maybe they did not meet a Medicare coverage criteria for payment. So we have to be very cognizant of all these different requirements. Also, over the last few years, there have been new models of care delivery that have been introduced, and some of these models have raised new challenges to how we do business in healthcare. What is the impact on quality? Are there any antitrust issues? How do these new models impact our relationships with physicians? So just a myriad of new scenarios that have come into play over the last few years. There's also a focus on access and security of data, privacy of patient information. As most of you are aware, the technology over the past few years has just increased and made so much more available to us. But what's happened is the technology has actually added a new layer of complexity and risk to our organization. So what are we doing as an organization to make sure that we're protecting this data? So with that, I am going to turn it over to Kyle, and he's going to talk about antitrust and false claims.
Great. Thank you, Susan. And hello, everyone. My name is Kyle Robinson. I'm an attorney here with CHI's Legal Services Group. The purpose of my presentation today is to review antitrust issues as well as the False Claims Act. So I will get started. Let's start with what is antitrust in general. Antitrust is the premise that the United States government should protect consumers from predatory business practices by ensuring that fair competition exists. And in order to do so, the government has developed a few statutes, the first of which is the Sherman Act. The Sherman Act was passed by Congress in 1890, and the purpose of the Sherman Act on the screen here is to prohibit conspiracies in restraint of trade that affect interstate commerce. Section 1 of the Sherman Act kind of expands on what a conspiracy is. A conspiracy can be more than just a conspiracy or a thought or a conversation between two people. It can be a contract or also a combination that reduces competition. Section 2 of the Sherman Act prohibits monopolization and attempts to monopolize. Now, the Sherman Act includes fines and potential criminal penalties, so it can be both civil and criminal in nature. So let's jump into a real-world example from 2011, and this example was really the premier entry of the Sherman Act into healthcare. We've seen it before in telecom and other industries, but in 2011, the Department of Justice pursued and settled an action against the Texas hospital system. That hospital system was United Regional Healthcare System of Wichita Falls, alleging that its contracting practices violated the Sherman Act. And what United Regional had done is that its insurance contracts required their insurance companies to pay significantly higher prices if they contracted with a nearby competing facility. So this effectively prohibited the insurance company from contracting with any of United Regional's competitors. And the DOJ stepped in and said, whoa, under Section 1, this is illegal, it's a contract. Under Section 2, this is an attempt to monopolize the market. And therefore, they imposed penalties and fines against United Regional. The second act I'll talk about is the Clayton Act. And the Clayton Act was passed in 1914. This is actually an amendment of the Sherman Act. And the purpose of the Clayton Act was to give more enforcement teeth to the Sherman Act. The Clayton Act is enforced by the Federal Trade Commission, the FTC, and the Department of Justice. Many of the provisions of the Clayton Act set out how the FTC or the DOJ can actually respond to violations. Other parts of the Clayton Act are designed to proactively prevent antitrust issues. As seen on the screen, Section 3 prohibits exclusive dealing arrangements, price discrimination, and requirements contracts. And Section 7 prohibits certain mergers and acquisitions. Here under the Clayton Act, we're only talking about civil penalties. So let's jump into another example, one that we're probably all at least a little bit familiar with. You might recall in the last 2 years, Anthem, which is our nation's second largest health insurance company, announced that it was going to acquire Cigna, which is our third largest insurance company. The Department of Justice again stepped in and challenged this, indicating that it violated the Clayton Act, and there were many disputes. But in February of last year, the U.S. District Court ended up siding with the Department of Justice, finding that this potential merger acquisition violated Section 7 of the Clayton Act. What the court found is that the merger would result in a higher level of concentration in the market, noting that the merger would result in higher prices along with other anti-competitive effects. Specifically mentioned by the court was that the merger would eliminate competition between the two companies for national accounts. It would reduce the number of national carriers available to respond to solicitations in the future, and it would diminish the prospects for innovation in the market. So here the government stepped in and from really a public policy standpoint blocked a merger of two of the largest insurance companies. The third act that I'll talk to you just briefly about is the Robinson-Patman Act. Again, this is an amendment to the Sherman Act. It was passed in 1936, and it addresses anti-competitive price discrimination. What the Robinson-Patman Act does is it prohibits a seller from selling goods of like grade and quality at different prices to competing customers where that price difference could cause competitive injury. And so I won't get into too much here, but one item to note is that this only applies to goods. It doesn't apply to services specifically. So there could be some health implications, but not from a service standpoint itself. We'll now move on to the False Claims Act. And the False Claims Act is very important to CHI and really any healthcare entity. From a personal perspective, I can say that we deal with the False Claims Act at CHI multiple times a day across our entities. The False Claims Act itself was enacted in 1863 and expanded in 1986 to include any federally funded program or contract. So by federally funded, really what we're talking about here is Medicare dollars or claims reimbursements from the Medicare program. What the False Claims Act does is it establishes liability for any person or entity that knowingly presents or causes a false or fraudulent claim for payment to the U.S. government. And let's focus on knowingly here for a second. You might think that knowingly could mean intentionally. However, the definition of knowingly is much more expanded. So knowingly means had actual knowledge, acted in deliberate ignorance, or acted in reckless disregard of the truth. So it's really a known or should have known standard. Now, the False Claims Act has strict liability, meaning that the government doesn't have to prove intent to violate the law. If the law was violated, you will be liable, is really strict liability. So I will move on to, let's talk about some examples of what false claims are. What operationally are false claims? Here are some examples. So charging for a product or service that was not provided. This is a blatant violation of the the False Claims Act. Overcharging for a service or product that was provided, delivering less than the service or product promised. So maybe if we receive payment for a bundle and don't provide that entire bundle. Charging for a product or service when a lesser price product or service was provided, so upcoding or upbilling. Underpaying or not paying money owed to the government is another example of a false claim. And then lastly, I need to talk about a case that was decided over the last few years. That is United Health Services versus U.S. Escobar. And this case is really the source of many, I would say, nightmares for in-house attorneys. And that's because the U.S. government approved a new theory that expanded the universe of what could be considered a false claim. And that theory is called the implied certification theory. What the implied certification theory holds is that whenever a contractor or provider submits a claim, that provider impliedly certifies that it has complied with all underlying statutes, regulations, and contract terms. And a violation of any of those statutes, regulations, or contract terms could result in a False Claims Act violation. So really, what does this mean from an operational standpoint? This is the scenario in which we've reviewed a claim and the service provided to a patient is adequate. We've looked at the claim and the information provided on the claim is adequate, but however, in providing that service, there are specific statutes or regulations that pertain to that service. If we had violated that statute, it could mean that the claim is tainted and therefore a false claim. An example of this might be if there are specific licenses required by providers to provide a certain service by statute. If there's a lapse in that license or we found out that we don't necessarily have that specific license, the service provider might be adequate and the claim submitted might be adequate, but we didn't meet that particular statute and therefore could be in a false claim scenario. And then lastly, with the False Claims Act, how is the False Claims Act really enforced? Or to take a step back, where does the information pertaining to a false claim originate? And there are two avenues that we've seen with False Claims Act. The first is a government investigation. So the government will investigate a provider's claims, and they might find that some of the information was false, and therefore a government investigation originated a False Claims Act lawsuit. The second is a very unique aspect to the false claim, and that is called a qui tam lawsuit. And a qui tam lawsuit is a type of whistleblower lawsuit that is brought under the False Claims Act and encourages individuals to report fraud and abuse. This allows an individual themselves, rather than the government, to file a lawsuit on behalf of the United States government, and it entitles the whistleblower to a percentage of any recovery plus any expenses, including the attorney's fees. So this allows an individual, generally originating inside of a provider's entity, to step into the United States government's shoes to file a lawsuit. And we've really seen an uptick in qui tam lawsuits over the last few years. So in 2007, the government used the False Claims Act to recover $3.7 billion in federal health care dollars. 3 of these $3.7 billion were a result of a qui tam suit, meaning they originated from a person that was a whistleblower. And last, I'll talk about the sanctions and penalties as they relate to the False Claims Act. From a civil standpoint, fines can be anywhere from $11,000 to $22,000 per claim, plus 3 times the amount of damages. So generally, we don't see false claims in like 1 or 2 at a time. Usually, we're looking at a population of claims that could be considered false. You can imagine how large these penalties can get. Each service or item billed constitutes a claim themselves. From a criminal standpoint, the government can impose additional fines or even imprisonment. We've seen quite a bit of imprisonment in blatant violations of the False Claims Act. And then last, many states have enacted False Claims Act of their own as they relate to state Medicaid dollars. So that's all I have. I will now turn it over to Ben Rowe to discuss the anti-kickback statute.
All right, thank you, Kyle. Like I mentioned, my name is Ben Rowe. I'm an attorney here with CHI as well. And I'm going to briefly talk about the anti-kickback statute and the physician self-referral statute, which is also known as the Stark Law. They're kind of companion statutes. They do a lot of the same things, but they do them in different ways. And so I'm going to provide a pretty poor analogy. The anti-kickback statute is kind of similar to commercial fishing. So those big, giant commercial fishing nets they use, you can put that into a decent amount of ocean, collect a lot of different varieties of fish. Whereas the Stark Law is more like spear fishing, where you're specifically going at a fish, and as I'll show later, the Stark Law can be a bit more unforgiving and painful than just that general commercial fishing net. So what these statutes both tend to do is they govern hospital relationships, financial arrangements with physicians and outside entities. So the first thing we'll touch on is the anti-kickback statute. It was enacted in 1972, and it was enacted to protect the integrity of the then fairly new Medicare and Medicaid programs, which came about in 1965. So specifically what the anti-kickback statute is it's a statute that prohibits the offer, payment, solicitation, or receipt of remuneration or payment, directly or indirectly, in order to induce business reimbursed under any federal health care program. And so similar to the False Claims Act, there's an intent basis under this statute, and that intent is knowing and willful. So in order to prove an anti-kickback statute violation, the government must prove the defendant knowingly or willfully entered into or attempted to enter into a transaction intended to induce referrals or generate federal health care program business. And an important factor on that is that ignorance of the law is not a defense. So a defendant couldn't come into court and say, I didn't know there was an anti-kickback statute, and I didn't know what provision of that statute I violated. All that's needed to be shown is that you knowingly and willfully entered into an arrangement to induce federal health care program business. And so just kind of digging into that prohibition a little bit, as I mentioned with the fishing net, it's a pretty broad statute. So it applies to all federal health care programs, Medicare, Medicaid, TRICARE, Campus, and it applies to any person or entity. Where Stark very specifically applies to physicians, their immediate family members, and entities that provide certain services. It does not solely apply to providers who submit claims under federal health care programs, but it also applies to anyone who transacts business with them. And it also doesn't implicate only those referrals, but it implicates payments for the ordering, providing, leasing, furnishing, recommending, or arranging for the provision of any service, item, or good payable by those federal programs. So the next thing we want to take a look at is what does remuneration and payment mean? So essentially that's broad as well. Remuneration includes anything of value. So it can include traditional money, it can include free or discounted services or items, which could be perks, gifts, free space or equipment, free meals, insurance, or trips. It also includes overpayments and underpayments within those contract arrangements. It includes waivers of copays or deductibles. It includes low-interest loans or subsidies, and it can include business opportunities that are not commercially reasonable. So again, it's anything of value. The liability on the anti-kickback statute runs to both parties on the transaction, so it could be the entity that pays or the entity that receives payment or remuneration. And the referrals or the inducement under a transaction do not need to be the only or sole purpose of an arrangement. Courts have interpreted the anti-kickback statute fairly broadly in that regard to create a one-purpose test. Whereas an arrangement has other legitimate purposes, but one purpose of the arrangement is to induce referrals or generate federal health care program business, the person or entity will still have an anti-kickback statute problem. So the way to get around the anti-kickback statute, the regulations have created safe harbors. And safe harbors are basically exactly what they state. They're the conduct that is clearly permissible under the regulations. And these are frequently revisited. They're revisited about every year to see if there need to be any amendments or additions. And as the landscape of healthcare changes, CMS and the LID will work together to issue new safe harbors. So they're coming out with new ones fairly regularly. The last new ones were in 2016, at the tail end of 2016. So in order to be protected by a safe harbor, your transaction needs to meet every single element of that safe harbor. And if it fits squarely within that safe harbor, the government has deemed that activity permissible, and you won't have any anti-kickback statute issues. However, if a transaction does not meet a safe harbor, you may still be in the clear. Again, it's a knowing and willful intent statute, so the government still has items that they need to prove. But the transaction will be open to more risk and subject to prosecutorial and court discretion. And within this slide, I've shown you three of the most used safe harbors that we see in the healthcare industry. As I said, there are currently 28 safe harbors out there, so there's a lot more than what's included here, but these are the ones we see the most. And generally speaking, once we get into Stark has exceptions. If you meet a Stark exception, you probably also meet an anti-kickback safe harbor, with the exception of a couple of very small things which I'll touch on briefly. One key note, there is no de minimis safe harbor. So there's no safe harbor that says this financial transaction is below a certain dollar threshold. We're not concerned about it. So that's not a very good defense under the anti-kickback statute either. A defendant could make the argument that, hey, this is only for a couple $100, we'll be okay under the anti-kickback statute, but that's a poor argument to make. Second, there is an exception under the Stark law for fair market value. There's not one of those under the anti-kickback statute for a safe harbor. So that's another important distinction to make there. All right, on my next slide, anti-kickback statute is both a criminal and a civil statute. So you can have criminal penalties, which are fines up to $25,000 per violation, imprisonment of up to 5 years, regardless of whether some of the remuneration was lawful, which harkens back to that one purpose test, or you can be hit with both. On the civil side, there are civil penalties up to $74,795 for each violation, plus 3 times the total amount of remuneration, again, regardless of whether some of that remuneration was lawful. Entities can also be looking at an exclusion from participation in federal health care programs. And for a criminal violation of the statute, that exclusion is mandatory. For a civil violation of the statute, there's discretion within the charging entities whether they want to exclude you from participation. And you could also be looking at potential False Claims Act liability, which Kyle also spoke about. Okay, so the second statute I'm going to talk about is the Physician Self-Referral Stark Law. It was named after Representative Keith Stark, who was very concerned about healthcare legislation during his time in the House of Representatives. And really, this one was also intended to protect the Medicare and indirectly the Medicaid program, but there was a little bit of a different focus on it. So during the 1980s, governments and state programs reduced payments to physicians for Medicare and Medicaid paid services. So as a result, physicians began combining with other healthcare entities through investment, ownership, and other financial vehicles. And the physicians would then refer their patients to these new entities, which they now have financial arrangement with, and then bill Medicare or Medicaid through those entities for the services that the physician was supplying, or referring, and then he would benefit because he had those financial arrangements in place. So this created an inherent conflict of interest that the government felt needed addressing. And really what they were looking at were 3 major concerns. The first was that these referrals to entities that the physician owned or had a financial arrangement with, they would be abusing the referral process and not giving the quality of care that the patient required. So the premise being that if a physician is going to select a facility he owns, he may select that facility over a facility with specialists that would give the patient better care. The second and more prominent concern of the federal government was overutilization. So if a physician was going to refer into a facility in which they owned or controlled, they're more likely to refer and order extra services that may not be medically necessary. And so that led into the third concern, that overutilization would increase costs of healthcare, both in general across the entire spectrum of healthcare, but more specifically under those federal programs that the government has to pay for. And so the Stark Law, like I said, is a spearfishing type of law, so it's a strict liability statute. As Kyle mentioned, strict liability means that there's no intent that needs to be proven by the government if they're bringing forward a case. So proof of intent to establish a transaction under Stark Law in a certain way is completely immaterial to the application of the law. If the Stark Law applies to your transaction and you don't meet an exception, which we'll speak about a little bit later, you're going to be liable under the Stark Law. So again, it's a pretty unforgiving statute if you fall within it and do not meet an exception. So what does the Stark Law prohibit? If a physician or a physician's immediate family member has a financial relationship with an entity, then that physician is prohibited from making a referral to the entity for the provision of a designated health service payable by Medicare or indirectly Medicaid, and the entity is prohibited from billing for such services unless an exception applies. So really this creates 2 prohibitions. It creates a prohibition against a physician making a tainted referral, and it creates a prohibition against the DHS entity submitting claims resulting from that tainted referral. And so within this definition on slide 12, you see that I've capitalized and bolded out certain terms. So those are the definitions to fall within the statute. So we're really quickly going to run through some of those key definitions. And although the Stark statute is a bit more narrow in its focus, the definitions under the Stark statute are still pretty broad. So in any analysis under it, you want to take a look at those definitions and make sure that you do not fall within them. If you fall outside of those definitions, you're in the clear and you don't need to worry about Stark. So the first definition is a physician, and it's basically what you'd expect a physician to be: medical doctor, osteopath. It also includes dentists and dental surgeons, and podiatrists, optometrists, and chiropractors. It's important to note that what it does not include are all of those mid-level providers. So nurse practitioners, physician assistants, nurse midwives, clinical nurse specialists, and CRNAs are not included in the definition of a physician. Our next definition is immediate family member, and really what this is if it's a family member that you probably invite to your Thanksgiving dinner, it's going to be included in this statute. It includes spouses, parents, children, brothers and sisters, step relations, in-laws, grandparents, or grandchildren, and spouses, grandparents, or grandchildren. So I guess really the only benefit to having this broad of a definition is if you're a physician and you don't really like your in-laws, you can let them know that they're messing up your financial arrangements with hospitals, but otherwise it's pretty broad. Next is what constitutes a financial relationship. And so the way the Stark statute is broken out kind of breaks these into three categories. So a financial relationship is a compensation arrangement between a physician and an entity providing designated health services, and that can be a direct or indirect compensation arrangement. It can also be an ownership interest between a physician and an entity providing designated health services, an investment interest, or a combination of compensation, ownership, or investment interest. And again, like the anti-kickback statute, compensation is anything of value, so it's not limited to money. It could be items or services as well, and discounts and other sorts of inducements. The compensation arrangement does not need to relate to the referral. So that goes back to the strict liability standard of the statute. So you can have a compensation arrangement that has nothing to do with referrals, but if that physician is still referring into an entity with designated health services, you're going to have to walk through the Stark law analysis. Last, the compensation arrangement itself does not need to be in writing to implicate Stark. So that's very important. As long as there is a transfer of anything of value from the physician to that entity providing designated health services, you'll have to walk through Stark to make sure you're compliant. And so as I mentioned, the statute breaks those financial relationships up into those three categories, and that's also how the exceptions are broken out. So under compensation arrangements, we have 25 exceptions that you can fit conduct into. Under the ownership or investment prong, there's 5 exceptions you can break your transaction into. And then if it's a combination of a compensation arrangement and an ownership investment, there's 9 exceptions. All right. The next definition is entity, and really the takeaway here is that entity is broad. It's any possible organization that can deliver designated health services. And as you can see on that last point, it also includes unincorporated associations. So the entity definition isn't as important as does that entity provide designated health services, which is our next slide. And as you can see from this slide, designated health services are also a broad category. That first point just proves it. Inpatient and outpatient hospital services are included in designated health services. So as we are mostly healthcare attorneys and healthcare corporate compliance programs that deal with hospitals, it includes most of what we do. One keynote on this, within some of these services that are considered designated health services, CMS has put forth some CPT codes that are specifically listed out as DHS. And so while this list is not exhaustive or inclusive of every single CPT code that may fall under designated health services, it's pretty informative. So it's a good place to start if you have any concerns that your services may fall or may not fall within START. Okay, so what are the START exceptions? Essentially, they're the escape hatch to stay out of trouble with the strict liability law. They are mandatory. So as I mentioned, if you fall within START, if you're subject to START, you have to need an exception, otherwise you will have START liability. And so listed here, again, the more common exceptions that we see in the hospital industry. And of these listed, they're all compensation arrangement exceptions, so they fall within those 25 compensation arrangements. Within those, with the exception of the bona fide employment relationship, there's kind of general elements that are required. And so, again, excluding that employment relationship, these arrangements need to be in writing. They need to be signed by all parties to the transaction, with payment set in advance, consistent with fair market value, and not determined in a manner that takes into account the volume or value of any referrals or other business generated between the parties. So those are kind of the hallmarks of those compensation arrangement elements. And then with each one, there will be specific requirements that you also have to meet. The only other thing I'll point out on this slide is that we have a fair market value exception. As I mentioned before, there's not one on the safe harbor regulations. But this is a good one to kind of fall back on if the financial arrangement doesn't fall into any other exception cleanly. So it's not only preferred to use, but it's a backup in case we need it. Okay, and the Stark Law penalties. So the Stark Law is a civil statute. There's no criminal liability assessed against the violation. And the penalties really relate to claims. And so that's another important distinction, and to harken back to my very poor analogy, why it's a spearfishing type statute. The Stark Law applies to claims. So where the anti-kickback statute applies to the transaction in general and the remuneration paid under that transaction, Stark Law penalties are all assessed against claims. So if you've been operating under a non-compliant arrangement on Stark for a significant period of time, and you've dropped a lot of claims under that impermissible financial arrangement, you're going to have a lot of liability. So the penalties, first and foremost, are that claims submitted in violation of Stark will not be paid. They'll be denied payment. Second, if money has been collected in violation of Stark, it must be refunded on a timely basis, and that timely basis is 60 days once the improper payment has been identified. In addition to this, there's monetary penalties. So the first monetary penalty is $24,250 for each claim submitted. So again, that's every single claim, and if you have claims add up, you're going to have a lot of liability. Or if it's an intentional effort to violate the Stark Law, there's a $100,000 fine for each scheme to circumvent the law, or alternatively, up to 3 times the amount claimed. Improper claims may also result in exclusion from participation in the Medicare and Medicaid program. You may also have potential False Claims Act liability, and a Stark violation may also equate to an anti-kickback statute violation. So Stark is one that you definitely want to get right. How this applies in the modern world. So I listed out 4 examples of settlements in 2017 that were either False Claims Act or anti-kickback statute liability or Stark liability, and some are predicated on False Claims Act suits. So really the one that I want to point out is that second, the Los Angeles Hospital, and that was Pacific Medical Alliance, who settled for $42 million based on allegations that it paid above market rates to rent space in physicians' offices and create marketing arrangements that provided an undue benefit to physician practices. So why I wanted to point this one out is this hospital had a very rough year in 2017. So later in October, they announced that they went up to California code for seismic standards. They had a really old building that would probably crumble if there was a major earthquake. And in order to meet the code compliance, they would have had to retrofit their hospital with at least $100 million. So they didn't own the land that the hospital was built on, and they decided they didn't want to do that, so they ended up closing their hospital. It was a 128-bed hospital with 638 employees. And while throughout they maintained that this settlement to settle the Stark and anti-kickback statute violations had nothing to do with them closing their hospital, it certainly didn't help when they had to look at retrofitting the hospital and the cost in doing that. 2 others that I'd like to point out are not on the slides, and they're industry, but they kind of exemplify the aspects of anti-kickback in different ways. So the first was a 2017 settlement with Walgreens, where they paid $50 million to settle claims that they violated the anti-kickback statute by improperly enrolling Medicare and Medicaid beneficiaries in their prescription savings club program. And why this one is interesting to point out is it shows that wide net aspect of the anti-kickback statute. So this case didn't involve any physicians or any hospitals. It involved Walgreens as a pharmacy and Medicare and Medicaid beneficiaries, which they offered discounts to enroll in their program. So the federal government took a look at that, and that was like an inducement to refer program business and went after Walgreens. The second case is just kind of a traditional anti-kickback statute case, but it shows the big dollar value that these can hit. So Shire, a pharmaceutical company, paid $350 million to settle allegations that they paid kickbacks in the form of expensive dinners, travel expenses, medical equipment, and payment for speaking engagements in exchange for using or overusing their products to treat foot ulcers by physicians. So that was a $350 million settlement, which even for a pharmaceutical company is a pretty big hit. So that's all I had to present on the anti-kickback and Stark statute. So I'm going to go ahead and turn it back over to Susan now.
Okay. Well, thank you, Ben and Kyle. And I think what you can see is just based on these 4 regulations, there are a lot of pitfalls along the way with what we do in healthcare. And so what do we do to try and avoid these pitfalls? So on this slide are some key risk mitigation efforts that we do at CHI. Many policies have been developed to address the relationships that we have with physicians, with vendors, relationships that employees have with others. One key, I guess you would say, policy is our physician contracting policy, and this one provides strict guidelines around activity related to physician relationships, especially what Ben was just talking about. Making sure that the relationships have there's a business purpose for entering into these relationships. There's fair market value, and just the relationships that we have with physicians who have ownership interest in companies, that CHI contracts with for products and services. So we have the physician-owned entity policy. Are these relationships influencing referral patterns and therefore increasing the cost of health care? Our conflicts of interest policy provides a process to identify potential relationships that may cause concern, and that could be with, employees that might have relationships with other entities or other organizations. We want to make sure that as an employee of the organization, the loyalty remains with CHI. So there's a lot of opportunity, there's a lot of things that can happen, and we just have to make sure that we have some internal controls and processes in place to be monitoring those types of things. What's related to data analytics, we use software and other tools to monitor data for outliers that may require further analysis. Regulations are very complex. We know that errors will happen, but it is important that we conduct ongoing monitoring and auditing, to check for patterns or trends to identify where we might have risk. We know that the government continues to increase its efforts in the area of data mining. More and more agencies are combining their efforts to share their data, to share their data analytic tools and their best practices for identifying and preventing fraud and abuse. Just last week, there was an article that the Veterans Administration is working with other government agencies to increase their data mining efforts. We know at CHI we've seen an uptick in government audits, probe audits, as a result of their data mining efforts. They're seeing aberrant trends when they run their data, so then they come back to the organizations, the providers, to basically prove that, we are doing what we're supposed to be doing. So it behooves us to be very proactive in this area. From a due diligence perspective, when we are, CHI is looking at aligning with another organization, acquiring, merging, whatever, we are involved to conduct various reviews related to billing and coding, medical necessity, physician contracts, and we assess their compliance programs because we want to kind of know what we're getting into if the transaction goes through and we're bringing these new entities into the organization. We also want to know that or ensure that we have a robust and an effective CRP reporting process. Many of you currently receive various CRP scorecards, updates that are designed to provide you with information to understand the controls and processes we have in place to to mitigate compliance risk. We also, our goal is to have a culture at CHI where people are comfortable bringing questions or concerns forward. And it's important that we listen and thoroughly review these questions and concerns. We also have an anonymous hotline in place as another mechanism to identify potential concerns. And, so really, the goal is, if an error is identified, no matter how we find out about it, we want to make sure it's corrected, and especially if there's any repayments that need to be made, we make the payments. But we also put processes in place to mitigate going forward. Okay, Ben, I don't think I can go forward. Make me the presenter. Okay, and then from a fiduciary role, what can you do as a board member or a compliance oversight? Okay.
Susan, try clicking on the slide.
Okay, I got it now.
Okay.
Sorry about that. So anyway, what can you do as a board member or a compliance oversight committee member in your fiduciary role? Well, obviously, you want to approve policies and procedures that come forward. Inquire if there are other areas that should be addressed. For example, you might become aware of a compliance situation at another organization, and you might have a question about, does this impact CHI in any way, your entity? And possibly if it does, what is CHI doing to address that? So, when those types of situations or questions come up, you want to, have a dialogue with your corporate responsibility office or your CRO. You also want to be aware of the healthcare regulatory landscape, the potential impact to the organization, how changes in regulations or new regulations impact your entity. Make sure you're receiving information you need to make informed decisions. Are you receiving compliance updates that you need from your CRO? You want to stay apprised of significant investigations. Ask questions about, what the status is, what's being done. Is management adequately addressing identified risks? Are they correcting processes going forward, and how do you know maybe the corrections that were put in place, how do you know that they're ongoing? You also want to participate in ongoing compliance education, such as this. We will continue to offer these quarterly webinars to help increase your knowledge of compliance and, what key risk areas we need to pay attention to. And then lastly, you want to understand the elements of an effective compliance program. And again, this can be done through the scorecards and updates and reports that you get from your CRO. But you want to make sure that you're comfortable that all the elements of the compliance program are being met and that they are operational. The other thing as a board member or a board compliance committee member, you really have the power to enhance compliance through your involvement in oversight committees or oversight activities and by integrating compliance throughout the organization. And again, in order to do this, you need to be informed about your organization's compliance environment. This slide has example questions that you should ask to help you in your fiduciary role, and I won't go through all of them, but just a few of them, what processes are in place to mitigate risk, whether that's related to physician contracts, whether it's related to billing and coding, are action plans that are developed as a result of audits, are they carried out in a timely manner? Are issues corrected? Are you aware of resources that are available to you to assist you in your oversight role? Over the last few years, the government has issued various guidance documents, and they clearly spell out their expectations for board members. And in addition, and how it's very critical that you are kind of a safety net for the organization. So you really need to take your fiduciary role very seriously. So in addition to these education webinars that we're doing today to help increase your knowledge of compliance, there's many other resources that are available to you. And so please contact your local CRO if you have any questions about these resources. So with that, I think we're going to open it up for questions. We have about 10 minutes left. And again, as a reminder, please do not ask any entity-specific compliance questions, given they might be of a sensitive nature. You should follow up with your CRO for these questions. So, Paul, we're going to open it up for questions.
Ladies and gentlemen, if you wish to ask a question, please press star and then 1 on your telephone keypad. Is your tone indicating you've been placed in queue? You may remove yourself from queue at any time by pressing the pound key. Once again, to ask a question, please press star and then 1 at this time. And 1 moment, please. Once again, ladies and gentlemen, to ask your question, please press star and then 1.
Okay.
Susan, maybe, this is Michelle. Maybe while we're waiting, one thing that might be helpful is if you shared with those that we have on the call some of the areas where we're using data mining. And I'm thinking most recently we've started to look at opioid prescriptions. That might be good for the audience just to hear some of the areas that we're looking at CHI.
Yeah, sure. You know, actually we really keep apprised of what the government's looking at, you know, or if something comes up internally, you know, like maybe somebody had a question about something, they had a concern about something, and we will look at those areas. Opioid prescriptions is one recently because that is a huge focus area. It's a nationwide issue, so it is something that we're focusing on. You know, how do we look at our data? Is it through like emergency room data? It's really to kind of get a handle on where we might have some vulnerabilities. The other thing is, you know, specifically around coding and billing, we look at a lot of those areas, and we have a pretty sophisticated software tool to do that. Recently, we've looked at the 2 midnight rule, which is a rule where you have to have, as an inpatient, you have to have a 2 midnight scan as an inpatient, and we're looking at those types of scenarios to make sure that we are meeting those regulations. And we also look at actually several areas of medical necessity, you know, clinical appropriateness. But again, I'm just kind of blanking right now.
I was just going to mention a couple of areas that we focus on as cardiology, and CHI has had a couple of settlements with the government when it relates to medical necessity around stents and some of the cardiac procedures. So that's one area where we continue to monitor and look for aberrant patterns with our physicians. So we very much pay attention to what happens within our organizations and then look at that across all of our organizations in an effort to make sure that we don't have systemic issues. Cardiology, spine, ortho, those are some of the areas where we're looking at statistically where are physicians' patterns. Is a physician doing too many procedures? We also look, is a physician doing not enough procedures that could pose quality of care issues, those type of things. So we've really very much moved towards using data mining to assess risk and where we focus our efforts. So I just thought it would be important for this group to know that we're doing that.
Yeah, I think another area too is when a new procedure is being introduced by one of the markets, one of the entities, and just do some monitoring around that to make sure if there are Medicare coverage criteria that needs to be met or certain aspects of delivering that care that need to be met. We'll do some monitoring around that. So I know especially that's come up over the last few years especially around more cardiac thoracic type of procedures. So even though the actual service of the procedure was medically necessary, it may not have met a Medicare coverage criteria for payment. So yeah, and especially when they're high dollar, you want to make sure that you're meeting all the coverage determinations.
Yeah, and that's an important note because, a lot of times people think that, if it's medically necessary, then no matter what, we can bill it. And we've had several situations where the provider or physician truly believes that the procedure they performed was medically necessary and they stand by it clinically, but the government has issued specific guidelines around when those types of procedures will be reimbursed. So there may be some instances where even though we're doing things that are clinically appropriate, we may not get the reimbursement. So sometimes we can have reviews with the government that really just focus around payment versus whether or not, we had a quality of care or clinical issue. So the regulations can be very complex, and really we're hoping through this webcast you understand that we're doing our best to look at those regulations, assess where is the greatest risk, and spend our time and effort in those areas.
Yeah, I think it's good to note, too, that, a lot of times because, hospital is like such a big area, but that's not where we do all of our monitoring and our data analytics because CHI is a big organization. We have a lot of other non-acute type of business lines like, the long-term cares, the home cares, the hospice, rehab, and behavioral health. So we are including all of those types of things, all of those business lines, and we're doing monitoring in those areas. Okay, Paul, were there any questions?
We have a question from Ben Ogletree. Please go ahead.
Yes. I'm in the banking industry, and our regulators, in times of stress, it's not uncommon for them to assess civil penalties or fines back on the individual board members from personal liability standpoint. Does that same thing ever occur in healthcare?
I'll start with that. Yes, and actually it's more common now than it used to be. We're actually seeing it in several cases that have come through, and the government actually issued a guidance document around that basically puts the word out that they will do that in cases where there was culpability or an individual was involved. The good news is we have not had that situation at CHI. We have never had a situation where a board member or a member of management were personally liable. But we've done education with our boards, with our leadership, that they understand if, there is definite intent and some other, reckless regard, those type of things, they can be brought into it. Very similar to what you see in the banking industry. The good news, too, I'll just mention, and I know this is of interest to board and committee members, is CHI does have insurance to protect our board members. The other thing is we are nonprofit, and that does provide us some additional protections. And so, I think that's why we see fewer cases, especially in the nonprofit healthcare business.
Okay, thank you.
Great question. Other questions, Paul?
We have a question from Michael Aves. Please go ahead.
Yes. I'm a board member. I previously served on the Physician Transaction Committee, but don't presently. In some instances, there appears to be very high compensation for specialists, and the range from family physicians, family practice, to the highest paid in the past is sometimes 5 or 6 times. And I've always found it difficult to really evaluate these very highly compensated specialists, even though, there are some market comparisons. Can you just generally comment on that?
Yeah, and Kyle, do you mind if I turn that over to you first to speak to that?
Sure. Unless, Ben, I think that might refer more to your section that you spoke about today, but we do have the Physician Transaction Review Committee that takes into account fair market value studies. It's the reason that we do have that committee in place. I believe you just indicated that you did serve on that committee.
Yes.
And while we certainly recognize that there can be some really discrepancy in what you would perceive as a difference in pay for specialists, we do rely on sort of that fair market value analysis. So we look at what other industries are paying their physicians, and some of those most productive positions are eligible to higher compensation amounts. Ben, I'm not sure if you wanted to jump in and discuss sort of the anti-kickback or START perspective on that.
Yeah, well, I mean, that kind of falls very squarely within START, so that's the concern that the PTRC is looking at in that instance. But I would agree with everything that Kyle said, that we're really going to rely on that fair market value assessment in analyzing any of those compensation arrangements, especially those that are looking to be a little bit higher.
And another thing that CHI has done is we've put in place a review body across the organization that looks at those highly compensated arrangements. And actually, before a contract goes forward to PTRC at the local level, that committee goes through and looks at that arrangement, looks for documentation of the fair market value, and actually makes a recommendation that now moves forward through PTRC as to whether or not they believe that contract should be approved. So not only is there that board oversight, but there's also an internal structure to support those contracts moving forward. And I can tell you, highly compensated physicians is one of the very strong focus areas for operations at CHI as they continue to manage costs. So many of those highly compensated contracts, have been reviewed and scrutinized and really looked at for reasonableness and from a business perspective as well. So there's a lot of rigor around compensation of physicians at CHI. Does that help?
Yes, thank you.
But it is an area that we are constantly focused on because our corporate integrity agreements that we've had at CHI, both at Towson before we sold that entity and in London, have definitely centered around our arrangements with physicians. And over the years, we have had rigor in reviewing all contracts, and that's really why the strong, stringent process for internal and external through the PTRC review process has been put in place.
Follow-up question from Ben Wilson, please go ahead.
Oh, no, that was my previous question. It's been answered. Thank you.
Okay, Paul, any additional questions?
No further additional questions. Thank you.
Okay, well, we want to thank you all for your participation today. If you have any questions or follow-up, please feel free to email me, Michelle Cooper, at CatholicHealth.net, 2 L's in Michelle, or please follow up with your local corporate responsibility officer, and we look forward to continuing to provide these quarterly webcasts. I also want to thank Kyle, Ben, and Susan for doing their presentation today and all the work that went into that. So thank you, everybody, and have a great week.